needs to be integrated. Indian constitutionalism is not bound by a single scheme of legislative relations or any homogeneous understanding of the concept of the 355. Your Lordship put to me that, look, there is a silence here in the Constitution. Well, I just want to answer that. I'll read what I have to say on this, so that it's on the record. My first statement is integration was completed when the Constituent Assembly of Jammu and Kashmir completed its task and the Constitution of Jammu and Kashmir was adopted on 26th of January 1957. The governing structure comprising the Constitution of India and the Constitution of Jammu Kashmir complement each other, and through the bridge of Article 370. The scheme operated without conflict for 70 years. This very scheme. There was never a conflict. 2. Through this complementary structure, the vast majority of provisions of the Constitution of India are applicable to Jammu and Kashmir in one way or the other. This was the integration meant. Nothing further needs to be integrated. Indian constitutionalism is not bound by a single scheme of legislative relations or any homogeneous understanding of the concept of integration. 3. Article 370, sub-article 3 is not silent. What is my answer to that? It is not silent as to the consequences reflecting the relationship between Jammu and Kashmir and India after the Constitution of Jammu and Kashmir was framed and the Constituent Assembly completed its constitutional task. This is further buttressed by the fact that in 1954, by CO 48, a proviso was added to 368-2. That can't mean that the 370 was silent on the consequences. If it was silent, 368-2 proviso would never have been added. Ensure that Article 370 could not be amended, even through the exercise of constituent power, and that by virtue of CO 48, the boundaries of the state of Jammu Kashmir could also not be altered, as long as 370 was in place. The Article 368 does not apply to 370 is clear from the fact that 370 starts with a non-obstante clause. So it was not silent as to the consequences. Next, there were no silences left to fill except the silence of the people of Jammu and Kashmir, who were never consulted and taken into confidence when issuing CO 272 and 273. That's the only silence that prevailed. Bilateralism is at the heart of the mechanism provided by Article 370, in terms of which laws applicable in the Union of India through the Constitution of India as applicable to Jammu and Kashmir are to be applied. It is this bilateral process which allows for a process of integration that is constitutionally envisaged in Article 370 of the Constitution, and any adjustment of the relations between Jammu and Kashmir and the Union must follow this bilateral process. And last of all, even with respect to 368 of the Constitution, the process of exercise of constituent power resulting in amendment of the Constitution is also given effect through a bilateral process. Bilateralism is at the heart of the said process because you have to consult at least get agreements of at least half the members of the states. That too is a bilateral process. Nothing can happen outside there can't be a unilateral act of an executive, not even parliament. Consider this, Manas, what we're talking about, a unilateral act of the president acting on the aid and advice of Council of Ministers, not parliament. So, Manas, with respect, I say there is no silence. So that was, Manas, just our submission, Manas, on that issue. And then kindly have a look quickly at the Constitution of India for a minute, Manas. Kindly, Manas, just look at this. Yes. Now, if you see, Manas, I'm not going to read the language. Just want to ask your lordships to notice three things. One, there are entire Article 370 has 2 colons. The rest are all semicolons. And the 2 columns reside where, Manas? They reside in D. There's a colon after D. And there is a colon after 3. 370 sub-article 3.
Colon after? D.
D, matlab 37 1D and colon after 370 sub article 3. So you cannot exercise that power independent because it's integrated. The process is integrated, and it's only a process that we are talking about. We're not talking about powers here. 370 is only a process of integration. And Miller's Constitution Bench in Manohar mentions that. And we are dealing with the process adopted by the government of India consistent with this process of integration. We're not talking about anything else, Millers. There is no unilateral notification issued by the government of India, by the President on the aid and advice of the Council of Ministers that's before you. There is no unilateral declaration. And I'll assume for a moment, Millers, there is a silence. How will your Lordships, Millers, integrate that silence into 272 and 273? Because 272 and 273 deals with 370 sub article 3 as it stands. You will still have to say whether 273, 272, 273 is consistent with the unilateral notification to be issued by the President, which is not there and which is not before you. It's not possible to match the two. It's not possible for you to state constitutionally, Millers, that 370 notification or under sub-article 3 will justify the action taken, which is 272 and 273, which has nothing to do with the notification. If you uphold 272 and 273, you will have to uphold it on its own terms, not on terms other than 270 sub-article 3 and the proviso, because that's what they have adopted. Even if you were to accept that argument, it's not possible for your Lordships